Very excited to have Harvey Silverglate joining us. I go back with Harvey some number of years. I worked for the Foundation for Individual Rights and Expression for nearly 15 years before I came here, and I've gotten to know him better in the 4 years since I became a full-time Cantabrigian, which is what I learned they call people who live here when Harvey told me. And I can say that Harvey is about the purest distillation of the essence of Cambridge you will ever find in a man born in Brooklyn. So I'm very happy to have him here today. And I'm going to hand it off now to Steve Carhart from our executive committee, and Steve will take it away.
Yeah, good afternoon, everybody. In ancient times, in the late 60s, I was the editor-in-chief of the Tech, and we were dealing with campus disruptions that have been yet to have been transcended. And the significance of free expression and the value of that to community was seared into my soul as we tried to keep an honest record of what was going on, who was doing what to whom, and what was happening. And one of the greatest compliments I received was being told by members of the MIT community that the Tech was the only source of information that they trusted to give an honest account of what was going on. We didn't always do it right completely, but we got it right most of the time. Now, going back that far, as I was learning that basic lesson, our next speaker was already out in the field protecting civil rights, civil liberties, and looking out for free expression of folks. Over his later career, he continued to defend folks that needed to be defending and couldn't find anybody else. He engaged in prolific journalism. He co-founded FIRE. He ran for the Harvard Board of Overseers, and a heck of a lot of other stuff that I'm probably not aware of. And when the fire bell rang a couple of years ago about free expression at MIT, and this old civil libertarian donned his red jacket and came out and pitched in with MFSA. Guess who was still out there doing the same stuff? Our next speaker, who needs no introduction, Harvey Silverglate.
Surprisingly, free speech has not been protected by the Constitution because it was not protected by the Supreme Court until relatively recently. For the most part, early on, censorship, despite the fact that there was a First Amendment, was the coin of the realm. This started to get challenged in 1943, just as World War II was turned the corner and was starting to look like it was going to be a victory for the Allied forces. West Virginia Board of Education versus Barnett. The question there was whether the Board of Education in West Virginia could enforce patriotic obeisance, pledges to the flag, and so forth. And while the majority said yes, there was a rather famous dissent that ultimately prevailed. The dissent was from none other than Justice Felix Frankfurter. And he thought that it was a form of mind control. And it was, of course, it was right out of Orwell, forcing people to say things they didn't believe or didn't necessarily believe. So that set a pattern so that when in 1969 the Tinker case arose, it came out in favor of the First Amendment protecting free speech and free conscience. Tinker versus Des Moines Independent Community School District. The question there was whether students who wore black armbands to protest the Vietnam War, and those of you old enough to remember the Vietnam War know that it was extremely controversial. It was not one of the wiser decisions made by the United States government to understate the matter. And it resulted in an enormous number of young people rebelling. I represented many, many conscientious objectors were not who did not get conscientious objector status because they could not say that their objection was religiously based, because that was the test, whether you had religious scruples. It was only later that the Supreme Court said that a deeply held, in the Muhammad Ali case, a deeply held philosophical opposition to war was entitled you to conscientious objection. But when I represented students, including many Harvard and MIT students, who refused induction, they were convicted. And even the judges were sympathetic to them because not a single one of them went to prison. They engaged in alternative service. They agreed to work in hospitals. They agreed to work in orphanages. I even had one who agreed to work for the Cambridge Police Department, who accompanied a patrolman on patrol, and that resulted in far fewer complaints for police brutality, by the way, because the cop had a Harvard student with him. That was an interesting sidelight, by the way. So, Tinker versus Des Moines, the Supreme Court said that yes, a student can wear a black armband. It's not to protest the war. It's symbolic speech, and it is not a disruptive of the enterprise of the school. And that was a major turning point. 1969, Brandenburg versus Ohio. This involved a Ku Klux Klan leader who was convicted under the Ohio criminal syndicalism statute, advocating the duty, necessity, or propriety of crime, sabotage, violence, or unlawful methods as a means of accomplishing industrial or political reform. And the Supreme Court reversed the conviction on the ground that there was a perfectly clear constitutional right to profess very unpopular points of view. Cone versus California, 1971. That involved a young person who wore a jacket, who not only refused induction, but wore a jacket to, quote, "fuck the draft," close quote. That was considered obscene. The Supreme Court held that that was, as I say, for this simple public display of this single four-letter word was not an offense. It may not have been polite, but it was not an offense. Miller versus California, 1973. The mailing of unsolicited sexually explicit material. Now, sex has been a focal point of censorship in this society since the Pilgrims landed in Plymouth Rock. Our country is highly sensitive, much more so than certain European countries, not others, certainly more so than France, for example, very sensitive to sexually themed materials. And the post office at one time said it would not deliver sexually explicit materials. I had a client who imported sexually explicit material. This was in 1971. Imported sexually explicit materials from France. And the post office department opened up the envelope, saw what was in it. It was rather racy. I saw the material and confiscated it. And I brought a petition in the U.S. District Court for remission of forfeiture. That is to say, to command the Postal Service to turn it over to my client. These magazines, the names of the magazines, okay, here goes. Anal Sex, Color Climax, and Color Orgasm. Those are the three magazines. And the reported case is United States of America versus Anal Sex, Color Climax, and Color Orgasm. Look it up, it's reported. And we won that case. The post office has a duty to deliver the mail, not to monitor the tastes of its customers. RAV versus the city of St. Paul. That involved the Ku Klux Klan burning a cross on the black family's lawn, and the ordinance was considered facially invalid because it was too broad. That is, the state could outlaw burning a cross on the property of a black family, but it couldn't outlaw burning the cross across the line on public property or in a public park. Obnoxious as the Ku Klux Klan might be, it has same constitutional rights as the NAACP. Equality under the law is focal, because if everybody's treated the same, the law ends up much more humane. The great Nat Hentoff, who was a friend of mine, wrote a book, Free Speech for Me, but Not for Thee, on the American left and right, and relentlessly censoring each other. And the point Nat was making was, if you have free speech, I have free speech. If we operate under the same laws and rules, then the law is going to be fairer, because what's good for the sauce for the goose is sauce for the gander. If you want to state the First Amendment in those terms, that sort of makes it easier to understand. So the bottom line is that Supreme Courts, liberal, which was under Earl Warren, conservative, the court became quite conservative when Donald Trump appointed a number of justices. The one thing that they agree on, and they're at each other's throats on a lot of issues, the one thing they agree on are the free speech cases. And that's to our benefit, because we're the beneficiaries. So I'd be happy to answer any questions.
Yeah, okay. Somebody got the mic? Okay. This gentleman here for starters.
Michael Schwartzman. So I'll take the risk of you claiming me being a bigot and etc. But just today there was a editorial, you might have read it, by 2 Yale students that said that something is wrong, and it's wrong to me too, but they tried to explain it. I'm not sure it convinced anyone, but there's something wrong with Yale University that in every pronouncement about upholding the free speech always says Palestinians and Jews. Now something is wrong. We all know that. Something is afoot. Both camps have behavior that could be called exceptional. Not always positively and negatively, but we know that there is a drift of one camp and a drift of another camp. And yet we understand, and you fought your entire life for that. It doesn't matter. Everybody is treated the same. So the students, almost as if they argued with you, wrote the following, and they said it better than I would, perhaps. At this rate, we wonder if we will soon be commemorating the Holocaust at a shared vigil for the Nazi lives lost in World War II. More likely, it will be an event to remember all victims of genocide with Palestinians front and center. Now, I'm trying to be objective. I truly am. Yet I think something is wrong. And your comment would help.
Well, if there are a number of people in our society who, despite the study of history and knowing what happened during the Second World War, actually think genocide is okay, that is a perfectly constitutionally protected point of view. And let me tell you why I think it is so important that people who are in favor of genocide, whether it's of Jews or Palestinians or black people or gay people or all of the groups that have suffered discrimination in the course of American Japanese during Second World War were rounded up and put into relocation camps, a blot on the nation's history. But hate speech is extraordinarily important to protect. Why? I went to Princeton in 1960 to 64. It was racist, it was anti-Semitic, it was homophobic. It was an all-male institution at the time, before coeducation. And people said to me, I mean, the reason I went there was I had a full scholarship. I couldn't afford anywhere else. People said to me, how can you deal with this? I said, oh, it's very easy. I really want to know who are the people I shouldn't turn my back on. And if they're free to call me names, I know who they are. They're out of the closet, so to speak. So hate speech, in my view, is more important than love speech. I mean, I like when people say they like me and they love me, but it's very important for me to know who hates me. And that's just an example of why the neutrality of the First Amendment has such a genius to it. It is protective because in this country, you are able to learn whom to watch out for. Yes.
At length, if you'd like, on an intensely personal question. What's it been like for you to be an unshakable free speech absolutist for over 60 years and watch the political spectrum completely spin around as to who is in favor of free speech and who's in favor of censorship?
Well, who is it who said, oh, I forget who it is, I wish I had Google here, Mr. Google. Nations do not have permanent allies, they have permanent interests. Free speech is a permanent interest. Sometimes it is more protected by the left. Sometimes it is more protected by the right. But as long as it's protected by the legislature and by the Supreme Court, we are all beneficiaries of it. And, during the McCarthy era, it was the right that was attacking the left. Eventually, McCarthy, the tide turned by a Boston law firm, Hale and Dorr, now Wilma Hale, when a young associate of that firm went before the McCarthy committee, and Senator McCarthy ranted and railed about his lack of loyalty. And a young lawyer from the firm, I believe it was Jim St. Clair, who was actually a friend of mine, who's since passed away. Wasn't it Jim St. Clair who said, "Senator, have you no shame at long last? Have you no shame?" And McCarthy was completely flummoxed. He drank himself to death. There are some great incidents in American history where somebody stood up to the tyrant, and the tyrant withered like an ice cube in the summer. And these people are very important. Jim St. Clair was a great hero, and I had a very good relationship with him. But we've been lucky that we have some people with guts who at crucial times pointed out, this is a free country. Another question.
Alan?
Hi, I'm Alan Tate, Masters 86, and I'm the chair of the Student Liaison Committee for MFSA. You talked about armbands, and recently in the news, a school in New Hampshire banned a bunch of parents who wore armbands in protest of female sports competing against other schools with males. They were forced to take their armbands off during the game. What advice would you give to those parents who could not display their opinion?
Well, it's clearly improper. It's unconstitutional for a public university to say that you can't wear an armband. Private universities are not technically bound by the First Amendment, but they have voluntarily undertaken to, if you look at the rules and regulations of Harvard and MIT, for example, two private universities, they have bound themselves to academic freedom. In addition, they take federal money, and that also binds them to certain constitutional norms. But again, if to say that people wearing black armbands is disruptive is nonsense. Yeah, it's disruptive of maybe some people's psyches, but that is not protected. In a free society, you have to build a certain degree of toughness. You know, I say that, people say, well, just because you're tough doesn't mean everybody has to be tough. Well, not true. If you're an American, you have to have a certain toughness. You have to develop a certain tough skin. People call you names. As I said, it's important to know who hates you. It's actually in your interest to be called names and to have people feel that they have the right to call you names. So, First Amendment is actually practical as well as theoretical. Another question.
Hello, my name is Ahmed, again from MIT Sloan, staff member. What I've noticed in some discussions about free speech, for example, I'm almost sure that the MIT statement on free speech includes some language that tries to indicate a balance between the rights of free speech and rights for free expression versus the well-being of marginalized groups. So my question is, do you think that these two principles are antithetical? If yes, why? If not, how do we make the case that free speech actually helps protect the well-being of marginalized groups?
Well, you're not entitled to comfort in this society. You're entitled to liberty. The nation has chosen, and it prefers liberty to comfort. If students are called names, they have to grin and bear it. If you don't want to be called names, then what you do is you go to a private parochial institution. If you're a Jew, you go to a yeshiva. If you're a Catholic, you go to a Catholic school, if it means that much to you. But if you want a liberal arts education, you have to be prepared to be challenged. My friend Randall Kennedy at Harvard Law School wrote a book, the title of which was Nigger. He was excoriated by fellow faculty members, and he said, well, the full title is Nigger, the history of a difficult word or something like that. And he was criticized by the faculty members. He says, well, you expect me to be writing a history of this word and call it the N-word? What's wrong with you? Now, of course, he was black, so he had a certain advantage. If it was a white author, it might have had him a harder time. But in fact, I'm taking my research assistants to a Randall Kennedy class shortly because I want to expose them to one of the great civil libertarians of our time. But free speech is, sticks and stones can break my bones, but names can never harm me. Free speech is enormously important, and absolute free speech is important. There are certain exceptions. The exceptions are, I believe that Steven Pinker mentioned them in his talk a little while ago. Falsely yelling fire in a crowded movie theater, often misstated as yelling fire in a movie theater, in a crowded theater. If there's a real fire, you want to yell fire. But if falsely yelling fire causes a stampede, And libel and slander has been, now I actually disagree with that. I think that what we should do with defamation law is if a newspaper or book or magazine says something false about somebody that rises to the level of defamation, that it really injures their careers, their economic prospects, and so forth, that newspaper or magazine should be given 2 weeks to issue a correction. And if they don't do that, then you could sue. I would make that one exception in libel law. So there are narrow exceptions that the Supreme Court has carved out, and I agree with those exceptions, and I agree they have to be narrow. But you know, we have one of the few we have certainly the freest society in the world, and one of the few societies that can qualify as free. Those societies, by the way, are dwindling. There's a very serious trend now where democracies have been replaced by autocracies. There was a small period of glasnost in Russia, and now Russia is run by a madman. You know, Mexico has had its problems. Argentina has its problems. All over the world, there's a battle between democracy and autocracy, and the part of democracy is free speech. You can't have a democracy unless you have free speech, free expression.
Pete had a question up front, or gentleman in the back? And then Pete, yeah. Go ahead, yeah.
My question has to do with what I believe is forced speech. It's sort of the flip side of free speech. And as an academic, I support myself by applying to NIH for grants. And in many of those grant programs recently, there's been a new type of statement that's required. And I think I just, in touching my computer, lost the page. But essentially, these things which are called statements to enhance diversity, they state first that diverse opinions improve science. And then, as an applicant, I have to say how my plan enhances diversity in order to improve my own science. First of all, I think, and I want your opinion, that this is just a forced speech, which I object to, but I also object to it on the grounds that I think it's based on flimsy science. And so A, I object to it because I think it's wrong, and B, I object to it because I object, because I don't want to be forced to render, to give, to just repeat an opinion, and I wanted to know if you think I'm barking
I have been
up the wrong
contacted
tree.
by a number of academics precisely this ground. My advice has been refuse to sign and let them fire you, and I'll take the case for free.
But, okay, you're on.
It's not a hard case to win. The Supreme Court has been very clear in the flag salute case, West Virginia Board of Education versus Barnett. Chief Justice Jackson, who later became, by the way, the chief American prosecutor at the Nuremberg War Trials Tribunal, said that in a free country under a constitution, nobody can be forced to. This is the flag salute case. There were Jehovah's Witnesses who would not salute the flag. They consider the flag to be a graven image, prohibited. You do not have to salute a graven image according to the Bible. And Chief Justice Jackson pointed out that we're in the middle of a war now, fighting for precisely these principles. And for a school to insist that somebody salute the flag just as World War II was winding down is a historical irony that, you know, you can't make it up. The student won the case. That's the controlling case for these diversity and inclusion. I have my own views about diversity and inclusion. I think that the reason we have diversity and inclusion programs is because public education is so bad that not every kid is qualified to go to college. And I have a solution. I've written articles about this. But improve public education if you want to help minority students.
I'd love to hear your thoughts on K through 12 education, but that's for another conversation. You pointed out that both liberal and conservative Supreme Courts seem to agree and make decisions reinforcing First Amendment rights. Have there been decisions, say, in the last 100 years from the Supreme Court that have actually gone the other way and perhaps had to been overturned, or we're still living with the negative consequences?
Not in the last 40 years. It hasn't been 100 years, but it's been the last 40 years at least. And now there's a across-the-board agreement, and it's generally enforced in the lower courts. By the way, the last
bad decision. You said 40 years ago. 45, 50 years. Just curious.
it was during World War I. There were some bad decisions. People who protested the entry of the U.S. in World War I and the drafting of I forget the name of the case, but it was quite a while ago. We have been fortunate that left and right have generally agreed on free speech. And of course it's obvious because the political winds shift, and they always shift in this country. Anyone who thinks that the current political, the reigning philosophy is going to last forever simply hasn't read any history, because that's not the way it works. Back and forth, back and forth. We have elections, and sometimes they turn out one way and sometimes another way. And it's very hard to predict. But as long as you're not sure, you have a self-interest in supporting neutral principles of free speech. It's that simple. Free speech for me means free speech for thee, to quote the great Nat Hentges.
I'm going to interject
Okay, we'll
and
go
ask
back.
a question.
Oh, all right.
So one of the big controversies that came up over the past year with the protests on campus and the offensive speech was what constitutes harassment. There's a definition I know, and it's something, something, and something. The MIT policy statement says something, something, or something. Could you remind us what exactly constitutes harassment under the First Amendment?
First of all, words alone never constitute harassment unless they're death threats. Death threats are not legal. If you have an encampment, for example, on a campus, that's lawful unless you're blocking students from getting to class. I represented during the Vietnam War a group of Harvard students, and this is what they did. There were some professors who were working as consultants to the Department of Defense. The students found out who they were when they broke into University Hall and they found the records. Okay, I represented them too. But they then waited outside the homes of these professors. This was at Harvard. When the professor was walking from home to campus, because Harvard provided a lot of housing for its professors so that they could walk to school, they would follow them closely, yelling, "Murderer, murderer, murderer." They went to court. The court said that the students had a right to follow their professors, but they had to stand at least 30 feet behind them, otherwise it constituted harassment. So it was sort of like, what's the kid's tale about the goose or whatever it is, with the little goslings following the mother. It was sort of like little geese following the father or the mother. They were able to follow the professor, they were able to get their message across, but they couldn't follow so closely that it constituted harassment. So nuance is important. The First Amendment is not absolute. Nuance is very important. And you would think that people who are intelligent can understand nuance. Sometimes they can, sometimes they can't. Depends on whose ox is being gored, I suppose.
But a nuanced question for you here. We just had, I'm from UNC, connected with the Free Speech Alliance there, And we just had Alex Berenson on Tuesday night speak, who lost his job at the New York Times, who was cut off Twitter for criticizing the lockdown and the research on the vaccines, et cetera. So the issue is not as clear for him. Clearly it was political speech, so that qualifies him, but it was the venue, not as clear as, say, a private versus a public university, but the mode of media communication being more or less a monopoly, like a TV station. How should we be thinking about that issue?
Well, first of all, academics should be protected to say whatever they want. Newspaper reporters should be protected. They're particularly newspaper reporters who are protected directly by the First Amendment. Now, the New York Times can fire a reporter, can fire a member of its editorial staff if it wants. It's a private newspaper, remember. But what they do is they violate their own principles, and they should be exposed for doing that. The Christian Science Monitor has a different standard. It's a private newspaper. It's connected to a church. They have a right to have messages that comport with the Christian Science point of view. But their mission is not the same as the New York Times, the Boston Globe, and the Wall Street Journal. My experience has been, by the way, and this is interesting when I say this, in the People's Republic of Cambridge, I get criticized a lot. The Wall Street Journal is the most protective newspaper of free speech and reporter's privilege that I'm aware of in this country, more so than the New York Times, more so than the Boston Globe, because it is avowedly content neutral. And it's interesting, it's owned by Rupert Murdoch, who is a pretty rabid conservative, but people don't know this, but I do for a reason I'll explain in a minute. When the family that owned the Wall Street Journal decided to sell, they had a provision in the, and Rupert Murdoch bought it from, I forget the name of the family. Yes. The Rupert Murdoch bought the paper. The selling family insisted on a provision that while Murdoch could govern the editorial page, he would have no control over the news pages. I saw the agreement because Roy Hammer, the lawyer for the family that sold the journal, was on the board of the ACLU of Massachusetts during the 30 years that I was on the board. And Roy was telling me about the negotiations for the sale of the paper to Murdoch. And he said this was one thing the family insisted on, that the news not be slanted. Editorials are by their nature slanted, but news is not. And that's why if you read, you want to know what's really going on in the country, read the Journal. It's the stories that are reported by its reporters. This was an unpaid advertisement.
So we go to the gentleman back there, yeah.
Yeah, speaking of people's republics, both China and North Korea enshrine free speech rights in their constitution, so clearly the written law is not enough. How can we protect a culture of free expression and liberty beyond the First Amendment as written?
How can we protect the First Amendment culture? Beyond the law. Well, that's something that's up to the schools, isn't it? And I would think that given the fact that academic freedom is a subcategory of First Amendment protections, that teachers in the elementary schools, in the high schools, as well as in the colleges, would understand the importance and the primacy of that right. I taught, by the way, in Cambridge Regional Latin School. I took a sabbatical for 1 semester. I did 2 things with that. One, I taught a course in criminal law at Harvard Law School. 2, I gave lectures in free speech to Larry Aronson social studies class at Cambridge Regional Latin, which my son was in. And I had a problem because the faculty at Ringe and Latin objected to my giving lectures because I was not a member of the teachers union. Can you believe this? Larry had to go down the fire exit, open up the fire doors, disable the alarm, open the fire doors, and I walked up the fire escape exit in order to get to the class. Could you imagine? I had to sneak in like a common thief in order to give lectures in free speech to the Cambridge Regional Latin School. We do have a culture where there are pockets of resistance, and we have to figure out how to overcome them. And that, you know, that's one of them.
I'll jump in here and ask a question that's been on my mind. Could you give us some guidance about how to think about free speech in the context of social media, where we're talking primarily about private individuals? We're not talking about public figures or media platforms as such.
This is the coming battle that's being fought in the courts, and it will ultimately be decided in the courts or by the Congress. My expectation is it will be decided by the Supreme Court. The problem is this. When I was younger, the means of communication were considered public utilities. I litigated a case for the Boston Phoenix. You can look it up, you can find it. Phoenix Media Communications, Inc. versus New England Telephone. This was what it was about. The Boston Phoenix was like the Village Voice. It was an underground alternative newspaper. One of the ways the Phoenix made money, it didn't make money off of its sales. No newspaper does. You make it off of advertisements. One of the things the Phoenix did was it had dating advertisements. They were kind of racy, you know, because the person taking out the ad described exactly the kind of sexual acts that he or she expected from a date. And it really got quite graphic. Trust me, it got quite graphic. And there was the way it worked was you took the ad out in the Phoenix and you gave your contact information so the person reading the ad phoned you in order to arrange a date or an assignation, whatever you want to call it. The New England Telephone Company said that it would no longer give the Phoenix telephone service because it engaged in prostitution and, you know, I always had a suspicion that because it was so profitable, the phone company wanted to do it instead, but that was my cynical approach to this. Anyway, we litigated the case, and we won. Phoenix Media Communications versus New England Telephone Company. The court said that the New England Telephone Company held itself out as a means of communication, not as a censor. They were the carriers of the messages. They were not the censors of the messages. We won the case. And, but now the problem is that you have these are private media companies. These are not public utilities. The New England Phone Company was a public utility. It was licensed by the Federal Communications Commission. And now you have a problem because what is Facebook? What is Twitter? Does Elon Musk have the right to censor what's in Twitter? Is it a public? These are being played out, and they will eventually be decided by the U.S. Supreme Court. But these battles have been fought in one form or another forever. Yes.
Gentleman in the back, and then, gentleman.
I'd actually like to thank you for leading up to the question that I had planned on asking, which is with respect to the ability of social media companies, privately owned social media companies, to censor or so on. I'd be curious on your take on, say, the Missouri Supreme Court case where the government actually was working to have certain posts or information removed, so the companies were actually acting as agents to do something that the government could not do by itself. And if I understand, the case was simply remanded back for not having standing. So if I understand the facts right, and I'm not an attorney, what does that say about how this is going to turn out? It doesn't seem to me like there was a decision in that case. Thank you.
I think the way it's going to turn out eventually is that these purportedly private means of communication are going to be considered to be effectively public utilities because they have taken the place of public utilities. The carriers of messages, which used to be done by a public utility, is now done by these private companies that have virtual monopolies. And I think they're going to end up being, the Supreme Court's going to say that they are effectively public utilities. At least I hope that happens.
But with respect to the government's ability to tell them to do things which the government by itself would not be able to do,
That's unconstitutional.
independent of whether they're considered a public.
Yeah, it's unconstitutional for the government to do that. That's pretty clear to me. It's, forcing somebody, West Virginia versus Barnett, forcing somebody to say something that violates their conscience. And
So when you said there had been no case in the last 40 years of the Supreme Court making a wrong decision on First Amendment rights, I would tend to argue that they did, because instead of remanding this back by claiming there was no standing, they simply could have said the government is clearly caught doing something they can't do, and it should.
The problem is this. The Supreme Court generally decides cases on the narrowest ground possible. They do not, it is not a platform for making speeches. It is not even though sometimes dissents do exactly that. It is not a platform to making pronouncements. It is a platform for deciding cases on the narrowest ground possible. And that's what they did in that case. If it ever comes to a case on the merits, I have very little doubt how it's going to work out.
I'm sorry.
There may be, one justice on the court that doesn't like the First Amendment, but no more than one, and probably none.
Let's see, Bill, did we get your question? Okay, very good. So we'll go to, thank you. Okay, the lady in the back.
So since we're at MIT, I will allow myself to ask you a more specific question. What's your opinion on considering code as free speech? And what is the possibility or a roadmap for the software to get the same exemption as knife and gun manufacturers, where if you use a knife to kill somebody, the gun manufacturer or knife manufacturer is not responsible? Where if you write a code that is used to blow up the White House, the software developer, and put it in open source, the software developer is responsible as of now.
I didn't hear the whole question. What was the whole question?
I'm sorry, it wasn't quite clear. Can we clarify the question a little bit?
Number one, do you consider code as free speech?
Code. Computer code. Do you consider computer code to be free speech?
Which code?
Computer code.
And number two, what, in your opinion, is the best roadmap for the software developers to get the same exemption as a knife and gun manufacturers who are exempt? If you use the knife or a gun to kill somebody, manufacturer is not responsible. Where if you develop a code and put it in open source, and somebody uses the code to blow up a White House, as a developer, you are responsible as of now.
The developer is not responsible. The developer of those codes is not responsible for how it's used. It's precisely the same issue if somebody publishes a book disclosing the secret of how to make an atomic bomb. That person is not responsible if somebody makes a bomb and blows something up. It is not, the communication of knowledge is not the same as incitement to crime.
Okay.
Yes.
Code is free
Yes.
speech? Yes.
Yes.
Okay, this gentleman here? Yeah. You got it. No, go ahead, by all means.
We're talking about First Amendment, so we're in the world of absolutes now, by definition. And I want to address your answer to Professor Morris's question. 50 years ago, I was a young professor in the Soviet Union, mathematics professor, no less. And in my thesis, I had to write how my thesis on recursive functions would promote the goals of the whatever 5-year plan I happened to be in. If I didn't do it, I wouldn't get fired, your services wouldn't be needed. I would just kill my academic career. And I suspect that even though I'm not in Professor Morris's shoes, he has a similar dilemma. Your services would be appreciated, and I'm sure they would yield fruit. But he's, again, we didn't discuss, but I think his dilemma is that if he resists, as you had suggested, and says, the hell with the principles, as I sometimes do, but I'm kind of semi-retired. All that's is going to happen, he's going to lose the grants, little by little. Nobody's going to fire him. There would be no need. He would wither and go away on his own.
I'm withered already.
All right. So, you don't have to give an answer to this. You're a First Amendment lawyer, and we know your position. But here is the position of people that have real dilemmas now.
I will give an answer. A public university could not do that to you. It would be too easy a court case.
Can I just clarify so everybody understands?
Yes?
It's the federal government that's doing it.
I know that. I know that. I'm getting to that. A public university could not do that. A private university could, unless it is using federal funds. Once it uses federal funds, it is bound by constitutional norms. Punishment of somebody for expressing an unpopular opinion or doing unpopular research or whatever it is violative of the rights of that person, and it would not take long to win this in court. The difference between public and private universities is very, very thin. The reason is that so many private universities take government money. MIT takes a lot of government money, but Harvard, Boston University, Tufts take quite a bit themselves. Once you take public money, you bind yourself to constitutional norms. If a school, I think there's Boston College, which is a Jesuit institution, takes a lot of public funds. It is a liberal arts college. It is bound. I believe there is one religious school. What the hell is it? That Hillsdale will not take any public, thank you, will not take any public government money because it wants to be able to run its own show. And I appreciate that. They're mocked by a lot of, people on the left. They have a perfect right to do it, and it's a very wise policy for somebody who wants to follow a parochial program.
Can I just add a subtlety to this so everybody really understands the situation? Forgive me. Just so everybody understands, the entity that's forcing me to make this diversity statement is the federal government.
Yes.
And as the gentleman in front of me makes a perfect analogy to the Soviet Union, the federal government simply, by virtue of the fact that somebody will score my application as deficient, won't grant my grant, and my career will.
Let me tell you something. It is unconstitutional. If it ever gets, it will get to the Supreme Court because it's such a widespread practice. But the whole notion of diversity, equity, and inclusion is going to be declared unconstitutional. It is unconstitutional. And as I've argued many times, this would not be necessary if public education would educate kids who wouldn't need the extra boost. It's as simple as that.
Another question.
Okay, yeah, gentleman back there, yeah.
I think the real question is the practicalities of academics vindicating their rights in that setting. Because what the federal government does, it's either thumbs up or thumbs down. And I've looked into this. I practiced law for 36 years, so I have a little bit of including some First Amendment cases. So I think it's the practicality of, sure, we would tell the professor he has a right to sue, but the government is really the all-powerful dealer. And for example, a lot of people talk about DEI on campus. Well, ever since Biden, the day after he was sworn in, he's issued 12 different executive orders about government funds and mandatory DEI at universities that take government funds. So there's kind of a wheel within a wheel when you're dealing with the federal government, who says it's justified, so sue us. So I have a lot of sort of empathy with the people that have to stare down the barrel of the federal government when all of the power is in the hands of the federal government.
Well, the solution to that is a sort of a bitter pill. One would have to vote for Donald Trump rather than Kamala Harris.
Let's see, who we got? Bill. Yep.
Harvey, can you talk a little about the protections, both First Amendment protections and libel law protections for satire, particularly now that you can make videos that are very convincing to make any words you want come out of a picture of anybody's mouth?
So what's the first part?
So First Amendment protection and libel law protection for satire, particularly with fake videos. Say, I can get President Biden to come up and say stupid shit, and am I protected?
Satire is fully protected by the First Amendment and should be. It's a very effective form of ridicule, and that's fully protected.
What about libel law?
Libel law is quite clear. Libel and slander, slander is oral libel, and defamation covers both written and oral. The exceptions to that are quite clear and have been for many decades through liberal and conservative Supreme Courts. You have to make, in order to be found guilty of libel, you have to be shown to have made a false statement, knowingly false, not an opinion, but a factual statement. You can call somebody an idiot, but if you say that they have been diagnosed as an idiot, that's a factual statement. But to call someone just an idiot is just a term of opprobrium, okay? Same with calling somebody a moron. You have to, it has to be shown that this was intentional, false statement, showing that the person engaged in criminal activity, and it has to impact the person's ability to perform their whatever their work line is. So it's it is vague, and it's true that the internet era has presented a tremendous number of challenges to First Amendment jurisprudence. I expect it will take another 20 years to work through all these subtleties. We're no longer in the era of Gutenberg. We're now in bits and bytes, as folks in this school know very well.
I think the lady in the back here, yeah, there in the black sweater. Yeah, okay.
Hi, my name's Leela, class of 24. So this is motivated just very naively by not totally understanding how the law works. And I also oppose mandatory diversity statements because they don't seem like a very good way of getting to people's, true beliefs if they're mandatory. But what is the difference between, so for example, like grant applications from the federal government, and one of my friends is applying for one right now, it asks her, because she's doing econ research, to explain why she thinks, econ research is important and how it will benefit the world. What is the difference between questions like that and questions like, how do you think your research will support DEI initiatives? Like, why can they ask one in its constitutional role, but not the other?
I didn't get the full question.
Well, the question is if the question is how can your research, economic research, improve the world, why is that okay compared to the DEI statement?
Just super naive.
Oh, you're saying that the purpose of the purpose of speech makes a difference?
No, I'm just asking because mandatory DEI statements for like federal grants you said are unconstitutional. I'm curious what it is about them that makes them forced speech as opposed to other like application components that also have you write something.
If I understand, just to clarify, if I got it correctly, this was in the context of economic research, and the question was something like, how will your economic research help the world? Something like that.
Yeah, the example's not important. That was just.
But I mean, but that would be germane to the content of the research proposal, I think.
Versus like if it's asking how does your proposal like further DEI, that's not germane.
Well, I think what the idea is that the DEI is not germane to the topic of the research. That's Harvey's a lawyer and the expert. That's my guess.
The purpose doesn't matter at all. One man's potion is another man's poison. The purpose doesn't matter, whether you have a good purpose or a bad purpose. If you have an illegal purpose, that's different.
Hi, thanks. Jason Merchant, University of Chicago. I just wanted to follow up on the diversity statements, your comments on the diversity statements that have been used in faculty hiring and promotion around the country. And as you know, and as we heard from our host, Wayne Stargart, this morning, MIT, President Kornbluth, has recently decided that MIT will no longer use diversity statements in faculty hiring and promotion decisions, and MIT has gotten a lot of good press for that, and it sounds like you would agree with that decision. What I want to know is that currently FIRE puts out a very closely watched ranking of universities on their commitments to free speech and expression. Right now, FIRE's ranking does not include any information about diversity. Is this still on? Yes. So right now, the ranking is done devoid of any feedback from whether a university allows, requires, or forbids diversity statements in faculty hiring. Given that it sounds like your view is that diversity statements are an impediment to full viewpoint diversity at universities, wouldn't it make sense for FIRE to take that fact into account in making their rankings?
I'm raising that at the next board meeting, coming up in a couple of months.
Great. I'm happy to help figure out how to implement that, how to get the data, in other words.
See, I think diversity statements are incredibly damaging to the educational enterprise. It has nothing to do with the educational enterprise. It's ideological, makes administrators feel good. By the way, I would fire 90% of the administrators. They're unnecessary. I don't mind deans. Deputy deans, assistant deans, deputy assistant deans. I mean, how many do you know there are twice as many administrators in American higher education than professors? It's obscene. No wonder it costs $100 grand a year to go to MIT.
Amen to that. Let's see, we have a question in the back there.
Hi there. So following FIRE and like firms, I have not seen the argument that if a private university is accepting federal funds, that they have to assimilate their free speech policy to constitutional standards, really push in a way that has required any private university to modify their policies. Today, there still is a very strong difference in what free speech policies look like at a private university versus a public university. Is there a landmark case that I've missed where that acceptance of federal funds has been used to compel a private university to open up their free speech policies for students?
Well, the federal government, regulations promulgated by the Department of Education, does have diversity standards. And it's the reason why if you accept federal funds, then you have agreed to have this oversight. I think that it's unlawful and should be unlawful. But they say the easy way to deal with it, if you're a private university, is to fire most of your administrators, lower the cost, and not have to take federal money. That would also, incidentally, it would improve the academic atmosphere of the university. As you can see, administrators don't like me very much. It would vastly improve the educational atmosphere. You wouldn't have speech codes and kangaroo courts to enforce them, the kinds of things administrators think up because they got nothing better to do. There are so many of them. They're not only useless, but they are harmful. And that would have, firing them would have great repercussions. You would need that much federal money. By the way, the federal regulations change according to who's in the White House. Does the name Betsy DeVos ring anyone's bell? A lot of these regulations were withdrawn, and then they were reinstated with Biden.
There's 4 major firms, also including FIRE, that litigate on free speech, but they will not touch private campuses when it comes to matters of students being able to have clubs on particular topics that the school would not like, or even excessive time, place, manner restrictions. Do you believe that there is standing to use the argument that the university is accepting federal funds to overturn excessive free speech regulation?
I think that the acceptance of federal funds does bind you to constitutional norms. FIRE does pick and choose its cases rather carefully, in part because it tries to establish precedents. It doesn't like to lose. And so we do focus on public institutions for the most part. That's a decision that the board takes up from time to time. We haven't changed it yet.
I think Wayne is advising me we have run out of time here. So let's thank Harvey for his wisdom and presence. And I think he'll probably be around a little while and you can catch up with him.